back on the record in Desert Cab, and the matter is now before the board for discussion, deliberation, and action. With the board's leave, I'd like to try to have us resolve first some procedural matters before we get into substance, and I then also in that context provide not that I'm the end all or be all, but some guidance on what I think the applicable law would be on some of these issues. And if that's everybody's comfortable with that. Okay. The first question that I think we have to determine is whether or not the administrator's position that we may not have subject matter jurisdiction is well taken. And I think that turns on whether or not we have to decide whether that there is a valid patent and that there is infringement. If not, the application is squarely before us. We have the authority to determine whether the application states a cause for relief and whether there is a preponderance of evidence establishing the elements for approval of a rate case. What I'm going to suggest is that we may need to park unless somebody feels strongly about this issue, that we make a preliminary determination that we have subject matter jurisdiction, that what we're really determining is whether a cause of action for relief has been presented to us. If in our deliberations we get to the point where somebody says, I can't decide without determining whether there's a valid patent and infringement, at that point, then there may be one or more of us who believes that there is a problem with subject matter jurisdiction. But I'm going to suggest to you, I think there is a path forward where we have subject matter jurisdiction, and the question becomes whether there is a cause of action upon which relief can be granted. Does anybody have difficulty with that? Somebody really want to dismiss the case because we don't have jurisdiction?
No, and I believe that the permittee has the right to submit an application for a rate increase and say nothing but I want one, and we still have jurisdiction to hear it.
That's right. Everybody okay with that? Okay. I will say this many times probably in the next few minutes. Our decision and every finding of fact that we make must be supported by a preponderance of the evidence. Nevada's Administrative Procedure Act doesn't say who has to present the preponderance. It does say that an applicant in some contexts has a burden. But it doesn't say that necessarily the applicant has to be the bringer of the preponderance of evidence. But we can't act if we do not have, for some important finding of fact, or for the ultimate decision, That's what the APA says. A preponderance of the evidence to support our decision. And the reason it says that is that sometimes we make findings of fact or conclusions of law that are mixed law and fact. And when we do that, the preponderance of evidence standard applies even when you're making a legal determination if it's a mixed question of law and fact. So just everybody keep in your mind that that's the standard for us. And what does preponderance mean? It's more like, we have a definition under the APA. It is more likely than not that the matter asserted is true. And in determining that, you have both direct evidence. Person A testified to A, or person A testified to X happened. You also have inference. That is, and I'll just give an example. In this case, we have an inference that may be drawn from the fact that not all certificated carriers agree with the rate case. And therefore, what does that mean? Or that a particular person took action based on their belief that something happened or would. That's an inference, and that is evidence. And so if it's more likely than not that something did occur or is the truth because of that inference, then you can be satisfied that you have established by a preponderance of the evidence what is necessary. There are certain standards of evidence under 233B 123 that regrettably are all applicable here. And I only tell you that because they're in front of us. Irrelevant, immaterial, repetitious evidence is excluded. We don't, it cannot prove anything. So if it's irrelevant, immaterial, or repetitious, it doesn't. Unlike the Bible, that two people say the same thing does not necessarily make it true. Okay. This following is very important, and I will explain in more detail. 233B mandates that in making a decision, we must give effect to any claim of privilege under the evidence code. We are not at liberty to ignore that. The legislature has decided Nevada agencies will be bound by that technical rule of evidence. An example is if we were a Massachusetts taxi cab authority, we could ignore that. But because in Massachusetts, that's not the law. In Nevada, we have to give effect to somebody claiming privilege. There are two kinds of privileges that have been asserted here. An attorney-client privilege under our evidence code and a trade secret claim of privilege. When Mr. George says, I've signed an NDA to protect commercial confidential information, he is asserting a trade secret privilege. He cannot be forced to testify on it, just like an attorney-client, somebody asserting the attorney-client cannot be forced to. And there are some important issues in our deliberation on this point that are critical. As to a claim of privilege, we cannot make an adverse inference. So with all due respect to counsel arguing, hey, they asserted, goose, good, what's good for the goose and the gander, I was being a little bit flippant. We can't assume what the answer might have been if the privilege had been asserted. That's in direct conflict with what we could do if it wasn't a privilege, because our evidence code, which we may follow, also says that if somebody has a piece of evidence and they willfully suppress it, you may conclude that it would have been completely negative to their position. But the ability, we cannot use that presumption in this case if it stems from a claim of privilege.
Mm.
So I understand counsel's argument. They're common sense arguments. The law doesn't really run in that direction. So we have to be careful in deliberating that we're not making an adverse inference or making a presumption that something is negative just because somebody asserted a privilege. There are two rules that may come up of import procedurally. The first is the concept of the doctrine of administrative res judicata, which says that if the same parties litigated to a final conclusion in front of an impartial officer acting within their jurisdiction in a quasi-judicial capacity, we are bound by the factual findings in that prior matter. I tell you this because there are arguments made on the basis of prior board action that are in minutes or orders. And it's when we get to deliberating, we'll want to talk about whether we are somehow bound by those. I will tell you where I'm headed there right now, which is we are not. But we can talk about that in more detail. There is another administrative law doctrine that is important here, and that is that the rule of stare decisis, that is precedent, previous action taken, which does apply to a court and does require the court at time 2 to be following what another court did in time 1, or even that same court, does not apply in a Nevada administrative case. The Nevada Supreme Court has said there is no such thing as stare decisis in front of an administrative agency in Nevada. You get to make this. You can make a decision today, Taxi Cab Authority Board, and tomorrow, 180 of that, you are not bound by that previous. So there's no precedent. So to the extent that there is a citation to some prior action taken, it is not precedent. There may be facts. If somebody's arguing that there's a fact in there, there may be collaterals. There may be res judicata, but there would not be. You're not forced to follow that previous action. This argument has been made. I am just going to point it out to you. NRS 706-1516 subsection 3 does not apply to us. That is the statute. I think Mr. Scherer made this argument. I believe the administrator pointed it out. That statute applies to the NTA. Not to us, and to when it is approving or acquiring technology. And so to the extent that there is some analysis of 1516 subsection 3. You can take it for whatever it's worth, but it's not binding on you. It's not binding on you. There were arguments under 706-8825. That's the technology fee provision. That likewise is irrelevant in this proceeding because that is a technology fee, as you know from our last hearing, that we pass to fund the administrator's budget. That is not something we pass to impose, to pay to somebody in the industry. So 8825, I point out to you is not helpful. We referred this matter to the administrator to appoint a hearing officer. That hearing officer conducted a number of hearings, made a number of decisions. No party appealed at any time to the board under NAC 706-975 any decision of the hearing officer. Accordingly, I'd like to ask at this point for a preliminary action that we conclude that because no appeal was taken, they've failed to exhaust their administrative remedies to challenge any interlocutory decision, and that we therefore ratify all actions of the hearing officer. And I'd entertain a motion on that if somebody's so inclined.
So moved.
Second.
Is there any discussion on that motion? Hearing none, all those in favor?
Aye.
Any opposed? One moment to make sure I get. Each. That's it. Any questions on the guidance, suggestions that I gave, or any other thoughts? Mr. Graff, did I mess up?
Nope.
Okay. You could tell me,
But
That's right. Believe me, he would tell you.
Oh,
I've learned.
Well, he does regularly.
Yes, he does.
He's usually discreet about it.
Mr. Chair?
Yes.
Let me ask. Well, based on, I just wrote this down here, based on the procedural process that you stated, in which I support, I want to ask respectfully from either of you if there is a motion with justification that someone may have as it relates to this item that we could build on, or if we can, or deliberate on it if we think otherwise. That's stated. That's kind of how I'm accustomed doing things when I'm on certain boards. But and I say that only because I'd hate for us to sit here for 2 hours and be redundant.
Yeah.
Again, stating a bunch of things that have already been stated, but just those procedural rules and the process that you've stated, I felt like I was in law school 101. I was like so inspired just now. I was like, geez, okay, that was great. But I'm really interested in hearing from you all in terms of where we are and
What's the path forward on
Yes, sir.
substance?
Absolutely.
Does other parties want to talk about that before I give my thoughts?
Oh, go ahead.
Hmm?
You're talking about procedure?
What
Yeah.
he wants, I think, remember Weekly saying, if you think there's subject matter jurisdiction, Chair, tell me how I get from A to B. I think that's what I'm saying.
Gotcha. No, you,
Okay. You okay with that?
I am. I think what he's asking is like, to kind of structure it from a decision type model as
Yeah.
opposed to a straight discussion type.
So I'll take a swing at that. As to whether the patent is valid, there is a federal legal presumption. As to whether there is infringement, your guess is as good as mine. That federal presumption, though, is, as was discussed during oral argument, rebuttable, which means somebody can say, pardon my use of the vernacular, but somebody can call yes, right? Say, let's go to court. So as to validity of the patent and infringement, I believe there is a path forward where we don't care. It does not matter to us. The only relevance of the validity of the patent and whether or not there's infringement is in judging whether the applicant in judging whether the preponderance of the evidence demonstrates that the requirements for the approval of a rate case have been satisfied. So it's not that we're deciding that the patent is valid or that it has been infringed. The question is, based on the record, does that information inform us in any way, shape, or form as to whether or not the elements of the rate case requirements have been satisfied? So here's where the rubber meets the road. To approve a rate, it has been the law of the United States since the 1890s and is the law today that in a contested rate case, the rates must be just, reasonable, and prudently incurred. Those are the terms of art. If anybody remembers the very first hearing in this case, I said, what's the cost of service? So in rate making, the first question is the rate just and reasonable? And just and reasonable are terms of art. Just means that the entity, the certificate holder, who is incurring an expense to provide a service to the public for which they have been granted a license, is receiving a fair return on investment. Reasonableness has been well defined. This is like black letter law. By that I mean you can find it in any encyclopedia. Reasonableness means that the rate is being determined on the basis of an actual cost incurred by the holder of the CPCN or the license. Actual cost is the standard. The next step is if they are being they're getting a fair return on their investment, and they actually incurred a cost so that the rate would be just and reasonable. The last step is it prudently incurred? The example, I'm going to give you an example of a recent situation that NV Energy had, because it's kind of easy to understand. Not so much down here, but in the northern part of the state, forests burn down, and they burn down electric lines, or the electric lines start the forest fires. And NV Energy gets to pay for everybody's house burning down if their electric lines cause the fire. So NV Energy says, I want to buy a horrendously expensive insurance policy so that I don't have I get to recover for these. Public Utilities Commission says, well, it would be much cheaper if you set up a captive insurance company, and instead of buying that insurance policy at retail, went in the reinsurance market and bought it at wholesale. So when you get around to setting up a captive insurance company, come back to us, which they are doing now. They didn't get their horrendously expensive insurance policy. They got an order that said, go find something that's prudent. This is too expensive. So that's the prudency. The other example is water company wants to decommission all of its water tanks and build brand new water tanks so it doesn't have to paint them and all of that. Well, that's horrendously more expensive than repairing the existing water tanks. So that last test is prudency. So to your question, my path intellectual is the rate being requested just and reasonable? The rate, I can't get to the rate being just and reasonable in my thought process adhering to the law, because Desert Cab has incurred at no cost. Now, that does not mean that it could not have come to us with fully executed agreements, that it had no choice in performing. It was going to perform them, and we could see that they were going to comply with them, such that they had incurred a cost. We would then determine whether they were taking any piece of that action for their profit to make them whole. In this case, we don't have to worry about that. We don't have to really worry about the justness, because no portion of this fee or this rate is being asked for the purposes of the return on capital.
Although you could argue the 12.5 cents is relatively vague as to how it can or must be used.
On that point, Member Decker, this is me, just me. The 12.5 cents is a bridge too far.
I will get there.
It is a bridge too far for the following reason. It suggests that without incurring a real cost, without us going through an assessment as to what is being required for the 12.5%, we are going to adopt a rate and give it to somebody we don't regulate. We're going to distribute that money to somebody we don't regulate, who has been in privity of contract and collecting fees for this service. Because the evidence, to my thinking, is not showing me I'm getting some new, really cool widget. I'm just paying for the same widget I've been using. So I can't get to the 12.5 cents at all because it's not been incurred. It's not being incurred by a certificate holder, and it is being paid to essentially subsidize or compensate a vendor to a certificate holder.
Well,
And what we do, and what we do when we look at their rates is we look at, okay, in the book of accounts, how much are you paying for your technology? And is that a reasonable charge? And what's the inflation on that? And for us to get in the business, I just think it's bad public policy. I don't think it matches the law, where you are imposing rates that generate tons of money that you pay to vendors. It would be like, this is a bad analogy, but that the only car company that would sell cars to taxi companies was XYZ car company, and it's going to go under. So do we then start subsidizing the car company? Do we subsidize insurance, workers' comp, or whatever? You know, we rely on the business judgment of the certificate holder in getting to that contract and coming forward with us and saying, I've incurred that cost.
well, and I have 2 points. One is, in the case of the operators who do use Captain, it does go to Captain, not for any additional service necessarily. So you could argue that some of that is profit because it's for an existing service that's already paid for. My issue is that the 37.5 cents has been presented to us as an emergency. And I'm not unsympathetic to the issue and how it's going to impact and probably come back to industry and this board. But you don't stop for milk on your way to the ER because your spouse is having a medical emergency. And 12.5 cents in my mind is stopping for milk on the way to the ER. So how much of an emergency is it when you go, well, hey, by the way, let's throw in a little extra. So that's my issue with the 12.5 cents.
So I can't get to not worried about the just standard because I'm not being asked to determine whether it's a fair ROI, a return on investment to the carrier. I can't get to reasonableness because Desert Cab hasn't incurred any contractual obligation. I've heard the arguments that they're being transparent, coming forward for us, letting us see what they're negotiating, but that isn't the standard. The standard is an actual cost of service. And that cost of service hasn't been. So I can't, I'm not personally able to get there. Others might be able to get there. On prudency, I don't actually have to go through the prudency analysis because no cost of service has been it's been incurred. But to me, the evidence, preponderance of the evidence is that this is not prudent. It's not prudent because the evidence we have is that another certificate holder terminated using Captain was able to transition to another service within 6 months, and that service is at or above the level of service that they were getting from Cap. And I understand the evidence is that it costs $730,000 for everything. Even if it costs $730,000 just to exit Captain to go to another provider, that would be a more prudent expenditure than a rate increase that is at the low end at 45 million, as I understand it, to as much as maybe 120 million, depending on the life of the patents. So to me, the prudency of going forward with the 37.5, I can't find that in my own head unless somebody here shows me how to get to that. So at the end of my analysis, well, let me back up. I get that there are some undetermined issues. What if it turns out that Z-Trip did that conversion and they now become the target of the next claim? Then we're back here, but there will be incurred costs then. I will also say, from a prudency standpoint, if you add up all of the evidence that goes to what it would cost to litigate, it does not get close to 120 million. So to me, the existential crisis to the industry is not the litigation. And without disclosing anything confidential, having looked at the applicant's financial reports, I am not convinced that they could not sustain those litigation costs. It might change the rate of the return on investment. But if you were to add up all of those costs, assuming they win, that would be a more prudent expenditure of money that every year at an annual review, they can say, I incurred this much defending this case. I need rate relief on that. And it would be an incurred cost that would be have been prudently incurred. So to my thinking, that only once there is a judgment of damages would the existential crisis occur that we would then have to face. There's a judgment with at 240, at Mr. Tomlinson's $2.40. It's going to be a huge judgment. And at that point, then we would be faced with bailing out the entire industry, and somebody in retrospect might say, how come you didn't in 2025 give them 50 cents? So somebody, that's something that could be, or is a weakness in the analysis I'm going through, because I can't solve for that today, because I don't have jurisdiction to solve for that. But I can have jurisdiction to solve for what I've just explained. I don't know if that helps you or doesn't.
Makes sense.
Okay. So now I'll shut up and let others speak, because I've inadvertently, or not inadvertently, but in response to his question, told you where I'm headed. And I do want to say this. This is a difficult conundrum. This is not an easy conundrum. And I see all kinds of motivations and cross motivations that create inferences in my mind. And all those inferences pretty much are wash, where you might say nobody has clean hands or everybody has clean hands. Take it away, James.
Well, I don't want to influence, do we have any new members that would like to go before? I don't want to, I say I don't want to influence them, but. Sure.
Alex, you don't have anything?
I'm learning a lot, taking a lot of notes. I
I
appreciate
know
all
you've been
the
taking a lot of notes on the transcript.
yes, and just learning a lot. And I agree with your thoughts. As I mentioned earlier, it's like having Rails with you guys on board, being able to explain. And as I have a question, you guys better explain it. So grateful for that.
Yeah. The institutional knowledge is helping me out a great deal as well. Reading through all of the documents that staff have sent to us, it's a lot to cipher through, and I 100% agree with you. It's a really difficult decision to make here, only because you listen to and the conversation based on what the really nice lady had to say in terms of this is not a patent hearing, but we spent a lot of time talking about patents today, right? Trying to decipher how do you make that work, because in America, you come up with a great idea, or you own, it's your idea. They tell you to what? Copyright it or have a patent. So on one hand, what does that mean? Do you really reap the benefits from that? And in this particular case here, I kind of got caught up in something when she started breaking those numbers down, but you said that really wasn't where we were at the time. So kind of got confused again on the 37% and the 12%. And so I'm kind of, whether since should I say, I'm sorry, thank you for the correction. So I'm kind of listening to where you all are going with it. I'm not that I'm riding on your decisions, because I can make my own decision, of course. But I think with the institutional knowledge that I'm gaining, like Member Vasquez here, it's helping me out a great deal to move forward. So thank you for that. So, yeah.
One thing that I'd like to on the record is that when there's an objection or there's a situation that comes up for debate, that you guys are clearly defining or bringing it back to something on paper on why the response to that. That's what I'm finding very clear and precise, right? And avoids room for error. So that to me has been newest, or the newest member.
I will try to break it down relatively clearly, because then I'll let the attorneys talk more, but I'm not unsympathetic to this problem. It exists. It's not going away. It's probably going to be back before us at some point. This problem could impact industry locally, could impact it nationally. And there's going to have to be some kind of solution. I get that. The board can't determine the validity of a patent claim. But beyond a demand letter in a meeting, that's all we have as far as a patent claim goes. So that's kind of what we have to rely on as far as whether there's any liability or impact to the industry to justify this rate increase application. The rate increase application, I would like to remind everybody, especially the board, is one way to deal with any potential liability. It's not the only way, but it's the way that Desert chose. In my opinion, it's the easiest way. If the board approves a rate increase, the public pays it, everybody's out clean, and everybody's got what they want. Doesn't really resolve the issue for industry overall, because there obviously are people that don't agree that that's the way to resolve it. It appears contentious as to whether there's any actual liability, even within Captain, but definitely within the industry. So that one way to resolve the potential situation, which is for us to approve a rate increase and have the public pay it, sounds premature to me. And for all the reasons that the chair stated. My biggest issue is it doesn't solve the issue. there is no agreement. There's a proposed agreement. Some people may opt in, some people may opt out, as we've heard. It may impact carriers in different counties differently. So this issue isn't resolved for us. This is step one. Again, a little bit premature. I have a huge problem with the 37.5 cents applying retrospectively to the future riding public. That makes it an abstract fee that I have a little bit of an issue saying that everybody who rides in a cab will be paying for liability that was incurred over the last 6 years, or for the convenience, as you heard, some of these.
So, Member Decker, before we go too far on that,
Okay,
I don't think that's the evidence.
okay,
I think the evidence is that if we were to approve the rate case, that IVSC would not look back. They would forgive the look back for prospective relief. So I agree with you. When we started the case, I thought that was the point, but I think as the testimony got more dialed in, and I know I wasn't here, but I promise you, I've read every page. I have watched the video. We have the blessing of watching demeanor of witnesses. But as it got dialed in, I understood, okay, so
so they're waiving the look back.
the look back is
Yeah,
not
I got
relevant anymore
I got
if there's a resolution. So
Okay,
I
well-
don't think we have a retrospective collection problem. Because that initially was what I thought killed the whole thing.
Okay, well, either way, you can't get around the idea that the 37.5 cents, Mr. Sheriff said, is based on an operator's cost, not the technology cost necessarily. So we're looking through the cost of the technology and saying we're going to get a percentage of a taxi ride. Well, the taxi ride is not what's being licensed. So again, in my mind, this makes all of this premature, maybe not so well thought out. If the end was a fee increase, then it makes a little bit more sense. But if the end is a resolution of some kind of patent liability, it makes a little less sense to me. And there's some fatal flaws. So I would not be, I'm not unsympathetic to the issue and know that it's going to have to be resolved, but I do not think that putting this in front of the board for the board to resolve this by approving a fee on the public from one carrier takes care of this issue, and I would not be supporting.
You're in the south.
I know. So,
Oh, yeah.
You did just touch on this for just a second there. And maybe this was already covered earlier. I just think it would be beneficial that was put on the record that all the members of the commission did fully review the full record, considering not everybody was here for everything.
One of my closing items.
Okay. Fair enough.
I got to be here for the whole hearing.
The record, I did not call you one time and say, why did you make that?
Did it other way. So I didn't as easily come to the decisions, I don't think, that Chair Reeser and Member Decker did. I came to it differently, but came to the same resolution, I think, in my head. When the application was made, I knew that at some point in time, there would be an agreement like this. And it wasn't present when the application was made, then the agreement came, and then we start reading the agreement, and the agreement betrays itself. So the agreement specifically says that there is nothing that's going to be paid by a licensee. That philosophically is my problem. I get it that the public could and possibly will in the future be asked to bear the burden of this issue. I just don't think that with this agreement and with this application that we can say with any preponderance of the evidence.
October doesn't say direct execution. I'm gonna go.
The rate being sought was just because they're not incurring any expense, or that it is reasonable,
Other way around.
or excuse me,
Just because they're getting an ROI,
Yeah.
reasonableness is that they have to have incurred a cost.
have to incur the cost. And then the issue of prudently incurred. I don't have so much of a problem with the amount. I think that there's a concern as to the split. I think that the split kind of, again, betrays itself. I realize the reason for it, and I realize the incentive behind it is to, you know what, hey, if we're all sharing in this, then we should all really share in this, and this is how we're going to express that. I think that if I was giving anybody any direction or, you know, for what information we needed to see, that would be one of the things that we needed to see. But when you look at Exhibit 4, which is the proposed agreement, it doesn't provide the clarity that I think that you have to have. And then this agreement is an agreement to agree. That's, you know, lawyers go through law school. It's one of the things you learn almost first or second week of law school. They say, well, it's an agreement to agree. Why is it an agreement to agree? In this instance, it's an agreement to agree because it's bound by the decision of this board. And then it says in its terms and conditions that if we don't decide or approve that payment, then everybody goes back to a drawing board and everybody's going to use their good faith efforts to try and resolve that issue. So there's a couple of other things that we could go through in terms of the agreement and that sort of thing. And it's not a Scrivener issue. It's not an authorship issue regarding the agreement. I think it's you play with the tools that are at the park. You try and determine what's going to happen and what's not going to happen. And one of the last troubling things that I have with the agreement itself is the covenant not to contest patentability. And then at the end, and it's not provision, it's the damage provision for breach. And that is to automatically raise the royalties due from licensee to 3 times the royalty amount then due to the licensor. So there's a provision in here that says that if you don't 100% participate and affirm the license process and their efforts to enforce the license process, they're going to charge you 3 times of what we're talking about in this license. It's still less than $240. It's $150, but it's still an amount that's fairly aggressive. And I guess ultimately, my decision will and is based upon the fact that I just don't think this agreement sets a very good precedent for the rest of the country. And that's what it's going to be used for. It's going to be used for other taxi cab authorities all across the country or other transportation authorities all across the country and say, hey, this is what we did. This is where we did it. And this is how we did it. It's the old push or pull philosophy for business and for the law. Do we push through a decision or do we try and pull it through in terms of getting getting a decision out of a court that says it's, you know, a valid patent and there's an infringement and here's what the amount should be. And then it's 8 people in a box potentially deciding what those damages should be. So then and what's weird to me, legal nerd wise, is when you look at 35 USC 282, which is the presumption that the patent's valid, what's the defense? Infringement or a lack of infringement. So that's, you know, one of the things that, because we don't have a preponderance of the evidence on those issues, right? And that's a concern that I have when I'm trying to make a decision like this. And that's kind of it for me.
Well, to amplify on your points about the contract, I'm even a step beyond that, which is they're not fine, not binding, not enforceable. The testimony is they're works in progress, in quote. They are indicative of current negotiations. So we don't even have, not only has not a cost of service been incurred, but we don't even know the terms under which the cost of service will be. And so the question is, do we approve and then have a year worth of compliance proceedings over what the contract should say before they enter them? We already know some members of the industry aren't going to play in that sandbox. And so to me, when the Administrators Council was talking about speculative, the agreements are speculative. They're not a deal. So that I get your point of analyzing them, and as I went through them several times with lots of concerns about, well, I don't like this provision if I'm going to approve this as a regulator. I don't think we should be in that space. That's why rate making says it's reasonable if it's an actual incurred cost, because there's a business judgment been made to incur that cost. And then the only thing we determine is what portion of that cost is prudent. We might decide 100%. We might decide, as an example, in the old telephone cases, the utility commission would say, well, 50% of this rate is actually benefiting the shareholders, so it's not going to get passed through to the ratepayer. So we're going to cut that in half. So prudency could be us saying, well, only 40% of this is prudent. So, but we don't even get to the prudency because we don't actually have a deal. That's why I'm one even step further. Before somebody, well, are people feeling like somebody feeling like they're close to wanting to make a motion?
Yeah, I can make a motion.
Would not yet. Just let me put a couple things on the
Okay.
record so that they're part of it. So you can say everything he talked about.
Sure.
Right.
Well, I'm gonna actually.
Only because I have a feeling I know who's going to write this decision.
Yeah.
And he needs some help.
Need some.
Okay. To council's point, not all members were present for all days of the hearing. Two of our members relied totally on review of the record. I relied on review of the record as a total, but I was here on the 17th. Member Decker and Member Graff were present on the 18th and 19th. So the question is, do we have a quorum and can we take action? And the answer, luckily, is that the APA says that we can. It specifically recognizes that we can render a decision when a majority of us have either been present during the case or read the record. This statute allows many agencies to have assigned the whole matter to the hearing officer and said, bring us a proposed decision and a transcript, which is what the Public Utilities Commission does. Only one commissioner hears the case. I am not troubled by this unless you are troubled, counsel.
No.
No. This is in 45 years, this is a rodeo I've seen many times.
And the rodeo starts this week. Look
Yeah,
at you.
then the airport was packed with people with cowboy hats.
Avoid Christmas
You
today.
guys all get out there and make some money. I'm just checking to make sure if there's any other. I'm going to just make one other observation. And I don't want any of the parties to think I'm throwing stones. I'm not. You guys have a difficult task ahead of you. As to believing that the case, that an actual cost was going to be incurred and that it was prudent, to me, there is a strong inference against the applicant because we didn't get a signed, sealed, and delivered agreement. Because that's what would happen in front of other rate-making agencies. It's not that you couldn't have processed it this way, you just would have brought a done deal. One that we could say, yes, this is a reasonable rate. It's a just rate and that it was prudently incurred. We don't have that. We have no evidence on what the agreement's going to be. So anyway, with that, I would entertain a motion. Oh, wait.
Do we want member Weekly and everybody that wasn't here to make an affirmation?
Oh, yes, thank you. Yes. Member Weekly, Member Vasquez, and I need to make the following certification. I certify pursuant to 233B 124, I think. Bear with me. Let me get this right so everybody can just copy.
No, you just set it
I
up.
just had that statute up. Yes, I certify pursuant to 233B 124 that having participated in the hearing on September 17th, but having been absent on the 18th and 19th, that I have reviewed the entire administrative record, including all prepared testimony, the transcripts, all exhibits, all briefs and papers filed by the parties. Can you make that same? You can say ditto, same certification.
Certify that I reviewed pursuant to 233B124, having been absent for bereavement, that I have reviewed all documents and transcripts
Transcripts, testimony,
and testimony
and the entire administrative record.
and the entire administrative record.
And I agree, and I ditto that, Mr. Chair, we both had, losses in our family at the same time, actually. So I would do want to put that on the record. Yeah. My siblings and I were caretakers of my brother who eventually passed.
Is that certification sufficient?
I heard ditto in there, so yeah.
Okay, thank you, Vice Chair. Anything else?
Do we need to say that there are no pending motions to supplement the record? Or anything like that? Okay,
We nailed the record at the beginning.
all right. I'm good.
So we have a motion.
I move to deny the second amended application of Desert Cab Company to adjust taxi cab charges to include a 50 cent per taxi ride pass-through software license charge on all trips as the result of a proposed negotiated license agreement by Captain with the third-party patent owner IVSC IP.
Second,
I'll second.
been moved in second. Discussion. Any further discussion on the motion?
You know, Mr. Chair, I was talking to, the council here. For me, I received all the information, but understanding, as I stated earlier, just all of it, thoroughly. I feel like I have an abundance of caution, in terms of supporting the motion, and so I feel like I want to abstain.
Okay.
So that would be my stance today.
Any other discussion? All those in favor signify by saying aye.
Aye.
Those abstaining?
Aye.
I am abstaining as well. I'm abstaining because as at the beginning of the proceedings, I disclosed to you that I had been approached by Captain after the application had been first filed, who disclosed to me at the time that no application was pending, when there was in fact an application, and then proceeded to discuss with me facts which are irrelevant to the decision we made today, but I do not intend to allow there to be a issue under the Administrative Procedures Act that would give rise to a judicial review. And do so by stating that had I not that disability, I would vote in favor of the motion. But deprive a assignment of error on appeal, I will abstain. The motion carries 3-2. Thank you very much.
Public comment?
Oh, yes, thank you. That takes us to our second to the last matter, which is public comment. This matter is set on our agenda for us to take input from members of the public on matters within our jurisdiction. We may not take action on those matters. I welcome any comments from the public present. Seeing none, are there anybody wanting to participate remotely?
No.
I'll close public comment and entertain a motion to adjourn.
So moved.
Second.
We are adjourned.
I'm gonna keep the notes.